Hello and welcome to Lecture 5 of the Magna Carta 2022, which is basically a polity prelims crash course for the upcoming Civil Services preliminary exam for 2022. Lecture number 5 is going to contain 3 topics which have to be studied separately and together at the same time. The 3 topics are fundamental rights enshrined in Part 3 of the Constitution, Directive Principles of State Policy in Part 4, and fundamental duties in Part 4A. The capital letter A signifies that it has been added later to the original text of the Constitution, which is the 42nd Constitutional Amendment 1976. Now, before we begin with this lecture, there are a few pointers I'd like to share with you, and these pointers are as follows. First, this is going to be a fairly long lecture, so I'd expect and request all of you to watch this at your own pace, because this is an incredibly important part and there are short questions that will come from here as far as the prelims exam is concerned. 2, this particular lecture contains topics which are both overrated and underrated at the same time. They're overrated, wherein I see a lot of students and colleagues in the industry get into unnecessary technical details, thereby wanting students to become legal scholars or jurists as far as these topics are concerned, which is highly unnecessary as far as the exam is concerned. It is underrated because the necessary focus which is needed for conceptual clarity on these topics often tends to be missing. So it has to be done in the right amount of depth. Thirdly, and this is fairly important, the reason there was a slight amount of delay in preparing this lecture for you is because, given the complications with these topics, I wanted to prepare proper PDF tables which you can download in a black and white format and revise a day before your exam. So therefore, the notes had to be prepared in due consideration, and you can download them as far as the website is concerned, and you will find the link in the description box below. Fourthly, specifically for this topic, it is recommended that you keep a copy of the Constitution handy. Now, what I would recommend is that you can download the latest text of the Constitution released by the government through a department called the Legislative Department, which comes under the Law Ministry. And of course, I will keep a link of the Constitution of India with you at all given points of time, right? So these are the 4 things that you should keep in mind, and ideally take a print of these notes with you, or either just keep these notes with you for reference when you are going through this lecture. It will help you revise and consolidate the lecture in one go, right? So these are a few things that you've got to keep in mind when we start with this lecture. Now, we're going to be covering dominantly 2 things as far as these 3 topics are concerned. We are going to be looking at a comprehensive review and the applications of rights, directive principles and duties. And then of course we'll spend some time as far as the basics of the basic structure is concerned. Now, when we do the comprehensive review and applications, we're going to do it in 2 stages. First, we're going to do a cross-topic comparison, which means we'll pick up the basic features, characteristics and key pointers of the directive principles, duties and rights together, and we'll understand how do they fare in comparison to each other, because questions are often asked from here. Then we will take a magnifying glass and we'll focus on fundamental rights and get into a little bit of detail as and when it's necessary as far as the exam is concerned. So these are the 2 stages of the first stage of the lecture, and then of course we'll move to the basics of basic structure. At the outset, to understand the relationship between fundamental rights, directive principles of state policy and fundamental duties, a clear analogy can be drawn with respect to a person who is buying a car and the car dealer. We understand that rights are minimum entitlements, directive principles are conditioned opportunistic advances that can be given as and when and if possible, and duties are obligations. So, for example, there is somebody who is a car buyer. the kind of relationship the car buyer will have with somebody who's a car seller gives you an insight into how rights, directive principles, and duties work. For example, if you're buying a car, you're entitled to inspect the car before you take the delivery of the car. That is your absolute right. So it is like a right. Depending on the rapport that you've built with your car salesperson, you may be given a free car cover or a free seat cover just because you've had a good relationship with them, or they are going through a good business cycle and they want to reward their customers. They're not bound to do this, but they choose to do this. This could be an example of directive principles. And you as the car owner prospectively will also have the obligation to take care of your car so that you don't have to incur unnecessary business expenses. So that kind of a comparison makes you understand through a very rudimentary manner what rights, directive principles, and duties actually are. Now that we do, we'll now move to a comparison of all the three and understand things in a relevant manner as far as the exam is concerned. So, let's begin. When we look at rights, directive principles, and duties, the first set of questions that are asked are identification questions. So, what is an identification question? An identification question is, in your prelims, they will say, consider the following statements. They'll give you a few statements and they'll ask you which of this is a directive principle or which of this is a fundamental duty. In most cases, you have to identify between a directive principle or a duty. You don't get questions on identifications of rights because they are fairly obvious and it is common knowledge. Now, these questions are very common and they are in a recurring nature as far as the exam is concerned. But a lot of times students get these questions wrong. Now, why do these questions are often attempted incorrectly? It's because students often rely on their memory because they've tried to memorize the list of directive principles and the list of fundamental duties. And in a stressful situation like the prelims exam, memory often tends to fail you. So what we have to do is that we have to figure out a logical way, a technically sound way, a derivative way through which we can arrive at the right answer without relying too much on our memory. And even if we have memorized it, we are able to reinforce our memory by making sure that the answer is a 100% correct one. So how do we go about this? If you get a question asking you to identify which is a directive principle and which is a fundamental duty, then there are two ways in which you can do this. And both the ways are complementary in nature. So the second you read the statement, you have to ask yourself a question. Who is going to implement this statement? If the answer is that the government is going to implement this statement, then the statement is a directive principle. But if you think the citizen is going to implement this, then the answer is going to be a fundamental duty. For instance, the statement says to promote international peace and cooperation. And you ask yourself a question, who's going to implement it? The government or the citizen? Think about it. Will you and I pack our bags, go to the Russia-Ukraine border and try to solve their ongoing crisis? The answer is perhaps not. It is the government through their diplomatic channels and their foreign policy machinery who will try to be a part of the solution to the larger problem that the world faces today. So, to promote international peace and cooperation, therefore happens to be what is called a directive principle. But if I say to cherish and value the ideals of the Indian freedom struggle, right? To cherish and value the ideals of the Indian freedom struggle. Now, who will cherish or who will value? Will the government value the ideals of the freedom struggle or will the citizens cherish? The citizens will cherish. So it becomes a fundamental duty. Now, there is a second test to this. When you read the statement, see the kind of words that they have used in the statement. If the adjectives that they've used are formal, are organizational, are institutional, are more serious in nature, then that statement is going to be a directive principle. But if the statements that they've used, the adjectives that they've used are informal in nature, they're personal in nature, they're individualistic in nature, they're casual in nature, then the statements would reflect to be fundamental duties. And that's a very simple way to go about it. I'll give you the same example again. To cherish and value the ideals of the Indian freedom struggle. Now, the government is a non-living entity. It's an institutional mechanism. It is incapable to cherish something. Human beings cherish. So if human beings cherish, which means citizens have to implement this, which means it's a fundamental duty. But if I say to organize village panchayats, so village panchayats have to be organized at a governmental level. You and I can't sit in our societies and say today we are the Gram Sabha. And to organize something means an organized institutional departmental kind of an effort. So it is a directive principle. Similarly, if I say to develop scientific temper, spirit of inquiry and reform, individuals have to develop a scientific temperament. Temperament is a human behavioral entity. So citizens, so therefore fundamental duty. And through carefully reading the statement, you will know whether it is a fundamental duty or a directive principle. For example, to preserve and protect wildlife sounds like a directive principle, and it is. But if I say to preserve and protect wildlife and have compassion for all living creatures, the second I add an informal meaning to the sentence, that means the citizens have to have compassion. You and I have to have compassion for all living creatures. So it becomes a fundamental duty. So the equations are: government implements it, formal words, directive principle; citizens implement it, informal words, fundamental duty. Formal words and informal words is always a fundamental duty because citizens entity has been added. So by employing a tactic like this, you will never get a question like this wrong, and you can easily move on to the next questions, not worrying about these questions that you have attempted. So that's the first entity that I wanted to talk to you about. Now, let's start with the first cross comparison, which is origin. Now, when we discuss origin, we understand which constitution in the world first spoke of the same idea that we are also using. The idea of rights, the idea of directive principles, the idea of fundamental duties. Specific rights, specific principles, and specific duties may exist in the exact form in other constitutions. But as a whole, the concept of rights has been taken from the US Constitution. Article 21, cut, copy, paste, is from the Japanese Constitution. But the idea of rights is the US Constitution. So if in the prelims you get a question, where have fundamental rights been inspired from? The answer is going to be the US Constitution. Now, directive principles becomes a fairly fascinating case because India was inspired by the idea of directive principles from the Constitution of Ireland. And the Irish people were further inspired by the Spanish people or the Constitution of Spain. But we were inspired from Ireland. It is like if a student A is copying from student B and student B is copying from student C, student A is still copying from student B. It doesn't matter where student B is copying from. So as far as India is concerned, we have been inspired from the Irish Constitution. We don't care whether it was from if the Irish had taken it from the Spanish. So that is something that we must know. As far as fundamental duties are concerned, because fundamental duties reflect a degree of obligations on the people, India was inspired by the idea from the Soviet Union or the former USSR. And remember, Russia did not exist at that time. In 1976, when fundamental duties were added to the constitution, there was no such thing as Russia. What we had was the USSR or the former Soviet Union. So where we've taken it from at that time was called the USSR. That's it, that's nothing else that you need to know. Now we spend some time on classifications, and this is slightly important. At the outset, we must know that there are no formal, informal, or derivative classifications of fundamental duties, which means we only have to focus on rights and directive principles as far as classifications are concerned. Now, when we discuss classifications of fundamental rights, we will first understand from a political science perspective, from a theoretical perspective, the classification of rights, and then we will understand the actual classification and how we go about it as far as the Indian context is concerned. So as far as political theory is concerned, and this is taken from your NCERT political theory textbook of class 11th, and that textbook tells us that there are essentially two ways to theoretically classify rights. The first is on the basis of derivation, and the second is on the basis of purpose. So what is on the basis of derivation? On the basis of derivation means where have rights been taken from? Where are rights originating from? And there are two kinds, or there are 2 points of origin theoretically. One is from natural law or the natural order of things, and the second is endorsement. Now, what do these two terms mean? When we say natural rights, or when we say that the rights have been derived from the natural law of the land, it basically means that these are rights that exist whether or not institutional mechanisms exist. They exist because of the fact that we are humans, the fact that we exist on the planet. They exist as an outcome of God, right? In ethics also we often say conscience is the voice of God. So theoretically speaking, these theories were written at a point of time where there was a popular belief in the existence of God, as of course it is today. So God is the origin of the natural order, or nature is the origin of natural order. So rights which are natural to nature, or rights which have emanated to us or descended to us from God, are called natural rights. Theoretically, there are 3 pure natural rights: life, liberty, and property. And every other right originates from life, liberty, and property. The meaning of life, the meaning of liberty, and the meaning of property can change over a period of time depending on social and other circumstances. But largely, this is the 3 purest forms of natural rights available. And endorsed rights are those which are endorsed by an agency. This could be the government, this could be the church, this could be a ruler, this could be anyone. Rights which are given to us by an authority that we are bound to listen to. So those are called endorsed rights. Okay. As far as the prelims is concerned, I don't think you should be asked a question, but because it's in your NCERT and it is conceptual in nature, I still think it is good to know, right? Now comes the theoretical classification of rights on the basis of purpose. Now we say on the basis of purpose, you've got political, economic, and cultural rights, and there could be far more. This is on the rationality of the rights as to why are they being used and for what are they being used. So political rights would mean the right to vote equally, the right to be treated equally. These are political rights. Economic rights would be the right to work, the right to get commensurated equal wages, fair wages. Cultural rights would mean the right to protect and preserve one's culture, the right to celebrate one's culture. So these are examples of cultural rights. It is from this theoretical domain that we come to a practical domain as to how India organizes its rights. Now, before I begin with this, I must be very clear and upfront with you. In the life of a UPSC aspirant, there are 3 truths. Your truth, the truth of yours as a student; my truth, the truth that I believe in as a teacher; and the truth that the UPSC believes is correct. And with great sadness, I must tell you, your truth and my truth doesn't matter. What matters is what the UPSC thinks to be correct. There have been several questions in the prelims which have been a matter of great debate amongst the community, such as what is the right to vote, such as what is the right to contest elections, such as what is the right to property. And everybody's had a differentiating view on those. But ultimately, it is the view of the UPSC which translates into the answer key which matters. So, my truth is derived from what the UPSC has marked as its correct answer in its official answer key. And that is something we have to remember. And what UPSC thinks is the right answer is based on what the NCERT tells you is the right answer, because it is the only official publication released by the government on the subject called polity. There is nothing else. NCERT is the only national publication released by the same government who conducts the same exam that you are going to be writing this year. So UPSC's truth is the closest to the truth mentioned in the NCERT, and therefore our truth on these issues must also be the truth which is mentioned in the NCERTs. Now, formally speaking, there are three kinds of rights in India: fundamental rights, constitutional rights, and legal or statutory rights. Fundamental rights are those which are in the Constitution and are in Part 3 of the Constitution. Only those rights specifically under Part 3 are fundamental rights. Constitutional rights are those which are in the Constitution but are in anywhere else except Part 3. So any right mentioned anywhere in the Constitution except Part 3 is a constitutional right. And as far as legal or statutory rights are concerned, these are rights which are mentioned in any law except the Constitution, in any other law except the Constitution. So for example, right to equality is a fundamental right, right to vote is a constitutional right, and consumer rights are your legal rights. Now, we were speaking about multiple truths. See, legal and statutory rights can cause a little bit of confusion, because a legal right is a right under any law, and the Constitution is basically a law. So technically a constitutional right and a legal right should mean the same thing, and its enforcement, they are the same thing. But in terms of placement, the UPSC looks at it differently. In terms of placement, the UPSC says a statutory right or a legal right mean the same thing, and they mean those rights which are in any other law but the Constitution. However, a further understanding will further dilute the differences between a constitutional right and a legal right. Now let's understand the differences. We will look at it from three parameters. First, the process of changing them. Second, the status that they enjoy. And third, the kind of enforcement mechanisms that these have. Now let's understand them first through change. As far as change is concerned, fundamental rights and constitutional rights can be changed in the exact same legislative manner. Now, what is the manner? First, only the parliament can change these rights. Second, these would be considered a constitutional amendment under Article 368 without state ratification. It is a constitutional amendment under Article 368 without state ratification. This means you will require something called special majority 2. Now, what does this mean? This means that more than 2/3 of present and voting in such a way that that number is more than half of the total strength of the House, which is the simplified version of special majority 2. And we know that there cannot be any joint sitting for constitutional amendments, right? Now, there are certain extremely important pointers to understand. That as far as the process of change is concerned, both fundamental rights and constitutional rights are very, very similar. So you're not treating fundamental rights specially by making them harder to change. the principles of basic structure would apply to the entire constitution. So you can't change a fundamental right or you can't change a constitutional right if it's violating basic structure. But if it's not violating basic structure, you can change both of these rights in the same legislative process, which is a special majority 2. The fact that we don't use a special majority 3 is largely because this does not change the power of the states to make any law. And because it is not changing the legislative power of the states, you don't need to seek the consent of the states. So center-state relations are not being distorted, and we are reinforcing rule number 2 that we studied in the first class, which is the federal balance rule, that the center is stronger than the states. So that's the first element. And therefore, fundamental rights and constitutional rights are equivalent in terms of the process of change. However, when we look at legal or statutory rights, because they're done through an ordinary law, they will only require a simple majority, which is more than half of the members who are present and voting in the houses, right? Now, a legal right can exist at an all India level, can exist under a central law, can also exist in a state law. So depending where the right exists, a state right or a state legal right will only be enforceable in that state, but a national legal right would be enforceable throughout the country, is applicable throughout the country with certain terms and conditions attached, but that's all right. But the process remains the same, which is a simple majority. So what do we understand through the process of change? That fundamental rights and constitutional rights enjoy the same degree of change processes as far as the constitution is concerned. And it is only that statutory rights are slightly inferior when it comes to the process of change. Now, let's come to the status, or let's come to the protection. Why are fundamental rights fundamental? They are fundamental for 2 reasons. One is the reason of status. What does this mean? There is a provision in the Constitution called Article 13 Clause 2, which we will also discuss in the context of basic structure in a while. Article 13 Clause 2 very simply says, no law can violate a fundamental right. It's that simple. If no law can violate a fundamental right, then fundamental rights are superior to everything else. You can't even change the constitution in such a way that it violates a fundamental right. You can't even make any law at any parliament or at any legislature which violates a fundamental right. So fundamental rights are therefore supreme. The constitution is supreme, but the fundamental rights are even supreme to the supreme. This kind of a status, this kind of a hierarchy is not enjoyed either by constitutional rights or by legal or statutory rights. That means, can you make a law violating a constitutional right? Yes, of course. Or limiting a constitutional right? Yes, of course. Can you make a law violating or limiting a legal right? Yes, of course. For example, if we are saying that the right to property is a constitutional right, then we also have parallel laws such as the Hindu Succession Act, the Transfer of Property Act, which poses limitations to property. We also have, we've also been debating the land acquisition law for decades now, which also has limitations on acquisition of property. So it's not as if you can't have those rights. Do we not have limitations on NRIs and foreigners acquiring property in the country? Do we not have limitations on acquisition and sale of agricultural property? We do. So technically we are limiting the right to property through laws. So is that possible? Yes. Similarly, when we say that you can make another law, can you make a law violating a legal right? Of course you can. Absolutely you can. That is why you would say, for example, if the right to contest elections is a legal right, then don't you have the Representation of People's Act, which gives you certain terms and conditions for the same? It poses limitations on the people to contest elections. So you are creating laws to further combat other laws or creating limitations within the same law. So no law can violate a fundamental right. This is crystal clear. Can a law violate any other right? Yes, absolutely. This privilege is only and only available for fundamental rights. Now the second reason as to why fundamental rights are fundamental is because of the enforcement mechanism. And this is the second reason. If a person's fundamental right is violated, the person has a choice. The choice is the person can either go to the Supreme Court or can go to the High Court. This is the oversimplified UPSC version. Of course, the choice to whether go to the Supreme Court or the High Court lies with the aggrieved individual whose fundamental right has been violated. It's entirely up to the individual, right? In reality, you can't show up at any High Court. You have to show up at the High Court of the state where your fundamental right has been violated. There are certain jurisdictional elements in place, but that's something you don't have to worry about. As far as UPSC is concerned, the Constitution is concerned, it's fairly simple. If your fundamental right is violated, you have the option, based on cost considerations, logistical considerations, based on the kind of relief that you want, kind of considerations, you can go directly to the Supreme Court as well as the High Court. There's absolutely no problem. The choice is yours. Now comes the interesting part. For our constitutional rights, whether it's the right to vote or whether it's the right to property, the Constitution is fairly silent about this. It's a grey area. It does not specifically mention what court will you go to if your right to property under 300 has been violated. In such a scenario, let's keep this on hold and let's understand legal rights. If your legal right has been violated, then you only have the option to directly go to the High Court. This is the simplified UPSC version. But this also comes with a little bit of a terms and condition. The term and condition is, if your legal right has been violated and there is no other legal mechanism which has been mentioned, then you can directly show up at the High Court. For example, a consumer right is a consumer right, and a consumer right is also a legal right because it's under the Consumer Protection Act. But the Consumer Protection Act also provides for a multi-tier consumer redressal legal system. You can't directly show up to the High Court and say my consumer right has been violated, because you have to go to the consumer forum. Understood? So that's the basic explanation that you must understand. Anyways, but in legal rights, you only have the option to directly go to the High Court. You can't show up at the Supreme Court. Now, this makes fundamental rights superior to statutory or legal rights. Two reasons. One, no law can violate a fundamental right, and if a fundamental right has been violated, you can directly go to the Supreme Court. Okay? Clear. Now, this is the area that we have to focus on. Remember, a legal right is a right that comes from any law. The Constitution is also a law, which means when there is no direct enforcement mechanism, we'll follow legal principles for any law, and legal principles for any law is directly enforceable at the High Court, which means constitutional rights can also be directly enforceable at the High Court, right? Which is why, as far as enforcement is concerned, constitutional rights and legal rights mean the same thing. All constitutional rights are in fact legal rights as far as enforcement is concerned, but all legal rights are not necessarily constitutional rights. Which is why last year when the UPSC asked you what kind of a right is the right to property, the correct answer was that it's a legal right. Because in terms of enforcement, the best answer that we had amongst the options was that it's a legal right, because constitutional right was not mentioned in the 4 options. So the next best option was the fact that it was a legal right. So this is how you can derive and logically come to a conclusion, right? Now, right to vote is a constitutional right. Right to contest elections is a legal right. Right to property is a constitutional right and also a legal right. Okay, because your past UPSC papers have been slightly confusing. Because one of the past year papers was, is right to vote, what kind of a right is right to vote? The correct answer was the right to vote is a constitutional right. It emanates from the articles surrounding the Election Commission. Whereas the right to contest elections, that originates from the Representation of People's Act and the other laws that are in place. Nowhere does the Constitution specifically mention that this is the entitlement that you have. The Constitution may give you an eligibility to contest elections, but does not give you the right to contest elections. Always remember the ground rule. If the question is according to the Constitution, or the Constitution refers to, or the Constitution contains, or in the Constitution, it has to be black and white in the Constitution. If it is not black and white in the Constitution, it is not in the Constitution. It's that clear, it is that simple, it's that concise, right? So that is something that you must keep in mind. So this is the classification in terms of the placement of rights as a whole. Now that we understand the placement of rights as a whole, we should look at further classifications of fundamental rights. Now that we understood the classification of rights as a whole, we should now look at the further classification of rights, of fundamental rights per se. Now, this also is slightly important for you to conceptually understand. And there are certain errors also in your standard textbooks, such as Lakshmikant, when it comes to things like these, largely because of the oversimplification syndrome, which is also why you will often not get questions like these in the prelims exam. But there are actually 4 ways in which you can classify fundamental rights. Okay. First is, who are the rights available for? Citizens or citizens and foreigners. Now, what Lakshmikant does is, it picks up the headline of those rights, 14, 15, 16, 17, 18, 19, 20, 21, 22, so on and so forth, and says, okay, 14 is available for everyone, whereas 15 is only available for citizens. That's actually technically not true, because a few of the clauses of Article 15 are actually available for foreigners as well, which is why, and the UPSC never asks you clause by clause questions. It will never ask you what is 16 clause 3 about. It will generally ask you about a fundamental right. So, which is why this oversimplification will not be converted into a question in the exam. Anyways, a simple way to do this is not to memorize it, but is through simple logic. And we have to apply the law of averages. If majority of the rights are pointing to a certain purpose, then the majority is the overall identification of the right. Which means if a majority of the rights of Article 15 seem to be for citizens, then Article 15 on the whole can be called a right primarily for citizens. Now let's understand this through an unrelated example, right? I will take your attention to the Hindu festival of Diwali. Now what happens during the Hindu festival of Diwali is that we follow something called classism of sweets. There are 2 kinds of sweets. One is the top tier, is the A grade, is the IAS of sweets, that is called Kaju Katli. Now it is a cherished sweet because of course it is difficult to make, and it is also considerably expensive. And the second is the MG Narega of sweets, which is called Son Papri. Now the IAS of sweets, the Kaju Katli, is for limited consumption for a limited set of people. You don't distribute Kaju Katli to anybody and everybody who you go wish Diwali to or who comes and wishes Diwali to you. Whereas on the other hand, you will distribute Son Papri as if it's raining Son Papri, right? Similar analogy applies here. If the government is supporting you proactively, is doing something for you, is providing you with some resources, some support, so that you can get better, the least is that you've got to be a citizen. But if the government has to make sure nothing wrong happens to you, or the government itself cannot take those bare minimum away from you, that has to be applicable for everybody. For example, Article 14. Everybody should be treated equally before the law. There are no issues about this. Everybody should be treated equally before the law. Doesn't matter if you're a citizen or a foreigner. Imagine if a foreigner has to be treated unequally before the law. How would the foreigner feel? But when you're giving employment-based reservation as an application of affirmative action, would you give employment reservation to citizens or foreigners? You'll only give it to citizens. Don't you think whether it's a foreigner child or an Indian child, they should be saved from exploitation? Whether it's an Indian woman or a foreigner woman, they should be saved from human trafficking. So exploitation rights are available to both foreigners and citizens. But what about state support so that people can celebrate, protect and preserve their own culture? Linguistic and religious minority institutions. Will you give state support for religious and minority institutions to foreigners? No, you will give it to your own people, because charity begins at home. That's a very simple way to understand what are the rights that are available for citizens and what are the rights that are available for foreigners. So that's one way to classify fundamental rights. The second way to classify fundamental rights is who are the rights available against, right? So obviously all fundamental rights are available for citizens and all fundamental rights are available against the state. The definition of the state is under Article 12, which again, like Article 13 Clause 2, we will discuss in the larger element on basic structure in the latter end of the class. But the state basically means central and state and local legislatures and executive. Basically that's the state. Anyways, but there are some fundamental rights which are available not only against the state, but are also available against private entities. And these private entities include individuals, corporations, organizations and associations as well. There are no discriminations on that. If you're a private individual or you're privately owned, you would still be collectively under the garb of private. Now understand this. There are some rights that are so excruciatingly essential that they're so non-negotiable in nature that you can't let anybody in the country violate these rights of anybody. And private is you and me. The simple way to understand this is U plus M plus E. Untouchability, movement and exploitation. Untouchability and exploitation are categorically, clearly, explicitly given, and movement usually translates into illegal detentions through judicial decisions and so on and so forth. Which is why you will also notice a writ of habeas corpus is available not only against the state but also the private, because a private individual can also illegally detain you, thereby hampering your movement, and therefore it is also available against the private individual as well. So untouchability, movement and exploitation are the three fundamental rights which are available not only against the state but also against private individuals. But, and this is the interesting part, what is available in the state against the state is explicitly written in the Constitution. The state shall not or the state shall. But if the right is also available for private, is a matter of judicial interpretation, which is why this will not be asked in the prelims exam, because this is a judicial interpretation given through various judgments by the Supreme Court and the relevant high courts in the country. So again, don't bother memorizing this. Then comes the third kind of classification as far as fundamental rights is concerned: self-executory and non-self-executory. Self-executory means just the right is enough. You don't need any other law, any other scheme, any other order, nothing to further support that right. For example, Article 40. Everybody has to be treated equally before the law and equal protection of law and so on and so forth. You don't need any law to support it. You have the freedom of speech and expression. You don't need a law to give you further freedom of speech and expression. That one line is enough. But reservation, whether in education or employment, or for example untouchability, where the article says untouchability is prohibited and it must be made punishable by an offense. The Constitution does not make anything a crime. The Constitution is not a criminal law, which means that the Parliament of the day will have to make a law criminalizing untouchability. So untouchability becomes non-self-executory. Reservation provisions under Article 15 become non-self-executory. because you need supporting laws on it, whereas you would require, whereas Article 14 or Article 19 Clause 1 are technically self-executory. So these are certain provisions that we must understand, and of course some reservation provisions are executory, some are non-self-executory. We'll come to that when we look at each of these in detail. Again, this is something which could be interpreted in multiple ways. So therefore, the UPSC is going to be very careful and not bother you with these ambiguous questions. Comes the fourth classification, compelling and enabling. This is derived from the third classification. A compelling right is a right which has to be done, the state has to do it as it is. Enabling is the right provides the state the legal reason to further activate that right. For example, one of the provisions in Article 15 says the state can make special provisions for women and children. On the basis of that right under Article 15, the state can make further laws providing for special emancipation and welfare for women and children. So that provision under Article 15 becomes an enabling right. Whereas 15 clause 1, where you have non-discrimination in public place in 15.1 and 15.2, that becomes a compelling right. So that's the difference. Again, just to make you understand how our rights essentially structured in the country. Now we move to directive principles. The classification of directive principles happen in two ways. One is on the basis of the nature, which is slightly more formal and is recognized across almost major law textbooks. The second is a kind of a classification which is given in your NCERT class 11th Indian Constitution at Work, and because it's given there, I thought we might just have a cursory glance over it. Again, there's a trick to do this. You don't have to memorize all the directive principles. What you could possibly do is, there are three kinds: Gandhian, socialist, or liberal or intellectual. If the statement is something which is grassroots in nature, orthodox in nature, basic in nature, rural in nature, conventional in nature, it will usually be a Gandhian directive principle. If the statement that we're talking about is about equal distribution of something, or equitable distribution of resources, or making sure people are getting what they deserve, then it is of course socialist or state intervention per se. If it is not the first two, if it is not fulfilling the criteria of the first two, then it will automatically be a liberal or intellectual. I might just go out on a limb and say, if you're not Gandhian or socialist, then you are a liberal or an intellectual. Some food for thought for much later, but for prelims this is more than enough. So for example, if I say promotion of Panchayati Raj or organizing village panchayats, grassroots rural convention, Gandhian. Equal pay for equal work, equitable distribution of resources, socialist. Uniform civil code, which is neither of the two, so automatically becomes liberal or intellectual. And as far as the NCERT is concerned, it says that directive principles contain three parts. First are, for example, goals. You will of course find this on page number 45 in case you want to go through this, just as an example. And by the way, the property example that I was giving you as to how property is a legal right because of the enforcement of this, and the truth is NCERT. I think it's on page number 46 or 47 of the same textbook, where there's a box on right to property, where the NCERT clearly mentions the right to property to also be a legal right. So that's where you get your authority from. Anyways, so goals, policies, and non-justiciable rights. Goals are basically endpoints that the nation should achieve. So for example, promotion of international peace, raising the standard of living, equitable distribution of resources. Policies are the changes that the government needs to make to achieve those goals. So uniform civil code, promotion of cottage industries, prohibition of consumption of alcoholic liquor, and so on and so forth. And non-justiciable rights would mean, for example, equal pay for equal work, for example, the right to work, for example, the right against economic exploitation. All of those are considered to be largely non-justiciable rights, right? So that is something that we must keep in mind, and that is how it should be up and running. All right. So these are some basics. Now that we understand the basics here, we'll now move to the second set of comparisons, which is a little more technical in nature. So, we now look at fundamental rights, directive principles, and fundamental duties. The first part that we must understand is the obligation on the state. This is simple. It is simply the impact that a right, directive principle, or a duty will have on the government. What is the primary impact? What is the basic impact that it has? The primary impact. Now, of course, rights are enabling in nature, rights are non-self-executory in nature. They can help the government, set up resources for a special set of people. All of those we completely understand. But the primary purpose of rights is to make sure that the government does not cross a line when it comes to its people. The government does not cross a line, protects the people from itself. It prevents certain actions from happening, which is why the obligation on the government is negative, right? The positive obligation on the government is not compulsory. It depends on the will of the government. If you think about it, a fundamental right says that you should have special provisions for women and children. What the government is going to do about it is something which will happen in due course of time. But the government has to make sure that they can't make a law discriminating against gender. So that's the difference between a positive and a negative obligation. As far as directive principles are concerned, they're of course positive obligations where the government has to take necessary actions to implement the directives which are in directive principles. And obviously, fundamental duties have absolutely nothing to do with the government in terms of its obligation. They have no obligation whatsoever. And in fact, and always remember this, we discussed this in the preamble also, if you have a technical, legally definable objective, it will always be a right, DPSP, or a duty. But if it is a poetic adjective, for example, heart, soul of the Constitution, preamble, but it is directive principles which are fundamental to the governance of the country. If you do this, you will be able to govern the country better, right? Now comes the obligation on the people. See, most fundamental rights, which are enabling in nature, give people the platform that is going to be supported by the government. For example, reservation policies by the government to bridge social inequity gaps so that people can come to a more egalitarian society. Government funding and sponsorship to make sure that you're able to protect, preserve, and promote your own culture, language, religion, so on and so forth. So it's a positive implication. You use the right as a basis for you to set up something which the government is going to do for you. That is why it is positive in nature. And directive principles have absolutely no obligations here. And as far as duties are concerned, it encourages people to do something such as develop scientific temper. It also encourages people to abandon certain beliefs such as violence and so on and so forth. So it has both a positive and a negative obligation on the people. Now comes the tricky part, the correlation part. Let's understand this through a very simple example. See, the Constitution guarantees a fundamental right. For the right to achieve its potential in its truest form, it must be supplemented with the right kind of measures by the government, which also must be supplemented with the right kind of acceptance by the people. And only then will you be able to achieve a complete developmental overhaul. I'll give you an example. The only constitutional amendment which, through the same amendment, amended the rights, directive principles, and duties at the same time and related to each other is the 86th Amendment, which is also popularly called the Right to Education Amendment, wherein Article 21A, called the Right to Education, which provides 6 to 14 years of free and compulsory education to everyone, was mentioned. Directive principles originally had what is called an age group of 6 to 14 that the government should try and provide for education. Here you're making it compulsory. Here you're saying whenever the government can, if the government can, when the government wants to, they can do it. So technically this and this becomes contradictory. So you had to change this to 0 to 6. Now, while the government is guaranteeing education, unless parents send their children to school, that right to education becomes incomplete. So the latest fundamental right that was added was to encourage parents to afford the opportunity of education to children in the age group of 6 to 14 years. This was added newly. This was changed so that now the government has a new objective to work towards, because they're already on the path of implementing this. So that is why directive principles, duties and rights, they're all correlative to each other. Simple, clear expedition. Now we come to enforceability. And we've discussed this in the preamble. Enforceability is often a misunderstood term. Enforceable by whom, right? Now, when we say enforceable by the parliament or the center of the state legislature or the center of the state executive, this means you're either making a law or you're making an order or something like that. Can the government make a law implementing a fundamental right? Yes, if Article 21A is here, then you have the Right to Education Act. The parliament can technically make a law on anything that it has the legislative competence to do so. And if education is in the concurrent list and there's a fundamental right on education, it is in the concurrent list, which means both the center and the states can make a law on this. The parliament chooses to make the Right to Education Act. And Article 21A very clearly gives the power to the parliament to make the law on right to education. It's that simple. It's all in the words of the law. Similarly, can we set up MG Narega? Can we set up the 73rd and the 74th Amendment to promote Panchayati Raj, which was originally an objective under Directive Principles? Of course. We are supposed to respect the national anthem. The parliament makes a law that says prevention of insults to the National Honours Act, where it is compulsory for us to stand when the national anthem is being played. Can you make a law on it? Yes, absolutely. Can the parliament make a law on any of these three things? Yes. Absolutely yes, no problem at all. But the real question is, and that's where things get very complicated, what happens if somebody is violating this? That is where the real meaning of enforceability comes, right? So, enforceable by courts or justiciable or just the word enforceable. If the government violates your fundamental right, can you take the government to court? Yes. If the government violates your directive principle, can you take the government to court? No, because of rule number 1, democratic mandate. If the government is compulsorily bound by a set of directive principles, then what is the business of being in the business of government? How will they get autonomy over the policy decisions that they have to make? So, no. Can you take the government or can you take a fellow citizen if they are violating a fundamental duty? No, you can't. On the basis of a law which has been created, yes. But just on the basis of a fundamental duty, the answer is an absolute no. So be very clear about this. In the prelims, they ask you questions interchanging these terms. Directive principles can be implemented with an executive action. Of course, yes. No questions asked. And interestingly, whether it is a right, DPSP or a duty, all of them are amended through the exact same process, a constitutional amendment under 368 without state ratification. You do not require the consent of the states, and the reason you don't require the consent of the states is because it is not changing center state powers and is therefore not in Article 368, right? So this covers your basic understanding, this covers your comparative understanding of rights, directive principles and your duties. Okay, now we're going to take a magnifying glass and now we're going to move to fundamental rights, and this is going to be the second part of the same lecture. So we'll stop here and I'll upload the second part of the next lecture in the next video. Okay, thank you.